and providing a speaker today for us. We also want to thank Advanced Professional Investigations for sponsoring lunch today. Robert,
they made lunch.
for doing that. Also want to make note that we're working on our calendar for next year. So if anyone wants to sponsor one of our membership meetings next year, get in touch with anyone on the board. We already have one group, Select Physical Therapy. I don't know if anyone's here in the room from there. There you are. So thank you for volunteering already to be a sponsor at one of our meetings next year. Let's start out, let's do some introductions. So maybe start, well, Robert's got his, everybody in the front row is chewing right now. Items. Looking at the chapter's financials, April had to leave early, so I'll give the financial report. We have money, which is good. We're still working on tying up all the loose ends from the conference, but it looks like we're almost going to break even. And so that's a very good thing. That's one of our goals this year, is try to break even on the conference. We didn't quite get there, but we're close, it looks like. So we'll be able to have maybe a little more financial information at the meeting in December. Speaking of December, that's our holiday luncheon and installation of new officers for the PRIMA board for the 24 year. I don't know if you saw the letter that was sent out. We had to change the date. There was a scheduling conflict with Colorado National Golf Club. They double booked over us. And so we had to bump out a week to the 14th of December, so hopefully that doesn't cause anyone to have to miss the annual luncheon. It'll be a lot of fun and good times.
Drawings.
What was that?
And drawings.
And drawings, yeah, lots of prizes. Also put out in the note about the education committee is looking for some suggestions. So Lori, if you want to make a couple quick announcements.
Yeah, so we're getting ready to plan not only the monthly educational sessions, but also next year's education sessions at the conference. So we would really like to get your input on what you would like to hear more about, what you'd like to learn about, what you don't know yet. So if you have anything, please send it to me. Sooner the better. We're really needing to get that planning going, so let me know.
All right, thanks, Lori. All right. Well, we have two presentations today. A lot of good information going to be given to us. We have Sam Light from CIRSA is going to be talking about contractual risk. And I know your office is like mine. You deal with contracts almost every day in some fashion. It is very important for our public entities to be able to transfer as much risk as we can contractually. And it's easier said than done. Yes, Jackie?
I'll let you finish introducing him. I want to add one more thing you didn't bring up.
Oh, okay. Well,
I
we'll
know.
do that. And then Tom Hebson from Tristar is going to be presenting on the total cost of claims in your program and the impact of ALAE. And he'll give a definition of that to those that don't know that acronym.
I don't know it.
You don't know it. It's all their overheads at the adjuster insurance that they pile on your claims. So. All right, go ahead, Jackie.
All right, well, like I said about the holiday party being moved, it's already up on the website. So please go ahead and look up there, register, get it on your calendar so that you will be there. Of course, I want to give people all the information at Colorado National about all of us being there, so please do that. Also, next time you are perusing the Colorado PRIMA website, up at the top where it says Member Area, Member Services, there's now a new area called Documents. Under Documents is where I have attached all of the PDFs and PowerPoints from presenters at the conference. So all the docs, if you're looking to look up any of the information, it's all there. If there's anything you want to go back and oh, I wrote a note about in that session and I don't remember what that slide was, everything is there. So thanks to Lori for grabbing all that stuff and getting it to me, and I loaded that up. Also, just want to let you know, November 15th, we will be sending out an email for the re-election of the board positions. So
That was next on my list.
okay, I see. Well, you introduced them, so I thought you were just past it. Okay, now you go. You take it back.
Well, that's fine. No, as Jackie mentioned, the elections for the PRIMA board are coming up. We have 2 current positions that are coming open on the board. It's a treasurer position and one of the director at large positions. And anyone that would like to apply or run to get on the board, send Jackie or I an email with your interest and intent. Also up for re-election are Lori Wisner and I as president and vice president. We're up for election for our second terms if that is ratified by the membership. So just let us know, and like Jackie said, on November 15th, the ballots will be coming out, and the announcements will be made at the holiday party in December.
And also about what Lori said about sessions, we really look to our vendors who go and attend so many conferences, and we know you guys see so many different speakers. So if you see something that you're like, hey, I think my Colorado PRIMA people would love this presentation or be interested, even if you just grab somebody's card, you don't have to do any work for us. Just ship the information to us. We're happy to do the work to contact them and find them, but we realize that you all have more eyes and you see more stuff than we get to see, so we are appreciative of you to, anything you see, please send our way. So thank you.
All right, thanks. Before we start the presentations, does anyone have any unusual, interesting things that are happening in your risk world that would be of interest to the rest of the membership to share? Like interesting claim, interesting, maybe precedent-setting legal issues you've heard about, anything like that that you'd like to share with the group? Okay. You guys must have fun. You guys must have nice jobs. You don't get all the crazy stuff we do. We just got another
It was the part about want to share.
Oh, want to share.
Yeah, that's true.
I will share. We just got another $4 million lawsuit as a result of our sheriff's office that came in 2 days ago. So, apparently, we're responsible for people who self-harm themselves in jail.
Yes, you are.
Yes. And the family wants $1 million per child for the inmate that hung himself. We'll see how that works out. Sad situation all around, but is it really worth $4 million? If it goes to trial, who knows?
Whose responsibility?
Or whose responsibility it is, exactly. So that's my one more story, if anyone else would like to share anything. Honestly, I need to go to work somewhere else. All right, well, with that, let me turn it over to Sam, who's going to talk to us about contractual risk.
Yay.
Thanks, Jeff. We insure police, so we feel your pain there. Here at CIRSA. I'm also going to borrow from Jeff. I think he said it very elegantly in far fewer words than I'm going to say it in. And the overriding theme of my presentation, you've already said it. Transfer as much risk as you can, right? That's a good thing. That's a good thing. But thanks for having me out to present today. I really appreciate it. I'm going to talk about contractual risk transfer for you all. I did make hard copies of my presentation. If you'd like to take one with you, I put them on the side table over there. Also, from the introductions, it's kind of a mixed group from different organizations and different roles within organizations. I hope my presentation's helpful to you, whatever your role is, and organization that you're with. I want to make my presentation as helpful to you all as possible, so if you have questions as I go through my presentation, feel free to raise your hand and we'll attend to your questions rather than me just going through my presentation materials. So, along with the mantra of transfer as much risk as possible, sometimes in your world who all deals with contracts on a regular basis, right? Sometimes in that world, you write a contract, it gets buttoned up. Right at the initiation or the start of the contract, everybody's kind of in a good mood because we're just starting a relationship and we're going to get something done on behalf of our community. But who agrees with this notion? Then sometime down the road, something happens, something kind of unfortunate. You pick up that contract and you say to yourself, people write the darndest things in contracts, right? With regard to the primary risk provisions of a contract, the indemnification and insurance provisions, you don't want to suffer that notion, right? You want to make the contract your best friend, right? And so that's what we're going to talk about. Some best practices and suggestions around key aspects of contracting regarding indemnification and insurance clauses, okay? Though I am an attorney, got to get this disclaimer out there. This isn't an attorney-client session, and I'm happy to give you suggestions from my perspective as an attorney and best practices, suggestions from CIRSA's perspective. But if you've got an issue going on in your own organization for which you need legal advice, that's for your entity's own attorneys. Hopefully, what they say will kind of neatly overlap. I hope they do. If they don't, they can call your attorney. Can call me up tomorrow and say, "What are you doing? What were you telling them?" Right? We're gonna touch briefly on indemnification and insurance. We'll talk about additional insurance a little bit, certificates of insurance, and a few remedies issues. Because remedies provisions, they tend to be where? At the end of the contract. And who's exhausted by the time they get to that page? I am for sure, right? But sometimes there's some pretty significant risk issues that are handled in the remedies provision. If we don't handle those appropriately, we may find that, we had great indemnity and insurance provisions, but we did some things in the remedies provision that really foreclosed or severely limited our opportunity to be made whole in a particular situation. All right. So I think, I told some folks I should really be sitting in the audience listening to you all speak because you're the experts on this. But I thought, just in terms of refresher around these topics, we ought to start kind of at the very beginning with the concept of indemnification, right? What is indemnification or hold harmless? By the way, who believes there's a legal distinction between the word indemnification and the phrase hold harmless? Is that a distinction with a difference? What do you think? I was puzzled over that, right? We'll break that down in just a second. But an indemnification agreement, right, that's simply the concept by where one party, the indemnitor, right, agrees to defend and assume the liability of another party, the indemnity, right, in actions brought by third parties. More simply, right, it's the concept where we're trying to shift responsibility, right, typically for the money damages and the insurance costs, we're trying to shift responsibility from one party to another, typically from one party that's sued to another party that's sued, or from one party that's sued to somebody who we thought should have been sued, who was actually responsible for the loss giving rise to the financial obligation. Getting back to that concept about indemnity and hold harmless, in Colorado, under Colorado law, they're basically treated as synonymous for most purposes. But I have a drafting suggestion. When we talk about the phrase hold harmless, we're really kind of implying release. Indemnity is the obligation to make me whole, right? Hold harmless is the idea of releasing me from liability. So in my world, again, you can follow your own attorney's advice on this. I mean, in my world, I think the best way to approach this is to have a separate provision with the release language, right? If you want to get a release from the other party, you want them to release your city, town, or county from all liability. You want a paragraph that says, I, contract party, agree to release and hold harmless city or county. Have that in its own provision, a release provision, and then have your indemnification and insurance provisions separated so that you have clear, operatively different release language from clearly different operative indemnity and insurance provisions. Okay? All right. Who agrees with this notion? No matter what the contract, no matter how long or how short, it could be an AIA contract that's hundreds of pages, or it could be a one-page agreement offered by some yoga instructor for your rec center. Everybody includes an indemnification paragraph in their favor, don't they? Yeah, they're everywhere. They're everywhere. My first thing in terms of contract analysis for public entities, if anybody asks you for indemnification, right, you want to stop and say, why are we doing this? Why should we, indulge somebody's other suggestion around indemnification? And to illustrate that point, which will help kind of inform some of the risk issues running the other direction, I wanted to start with this hypothetical. Let's say your entity is hiring a contractor to perform janitorial services for your buildings that your entity owns, and that's nice. We found a good bid, good price. They seem like a great company. Is everybody kind of taxed? We're overworked, under-resourced, right? So sometimes we'll say to the vendor, why don't you send us your form of contract? Maybe that'll keep us going, get this thing done quickly. And they send over their form and it says something like this. The owner, that's you, right, agrees to indemnify the contractor against any claims arising from the agreement and the performance of the work you further agree to maintain CGL coverage at your expense and name them as an additional insured. Can you agree to that? Should you agree to that?
No.
Well, yeah, you probably can, should you? Well, no, I mean, if sure you can agree to it, but people write the darndest things in contracts, right? And what you've just done there is you've essentially agreed to protect the contractor against any liability from their work, right? Even if they cause that. So, yeah, that's why I suggest to people when they're looking at contracts, they're struggling with this issue. First, in this broader context of a relationship between, yes, Jeff?
How does Article 11 of the state constitution apply, where it says cities and counties are prohibited from assuming the liability of any third party via contract?
Yeah, so I'm going to break that down a little bit more, but there are some, for public entities, there's definitely some reasons, right, that you may, I found that entities have different approaches on this issue, but there's the Tabor Amendment, right, and there's the constitutional provision you mentioned that I think limit the ability of public entities to provide indemnification. And as we'll talk about in a second when I get that slide, some entities take a real hard line on that, some take a softer line, and sometimes you just like, no matter what you do, you might still be faced with an indemnification obligation. Like from, public entities will appreciate this, in particular from a railroad company. Whoever needed a railroad crossing agreement. Yeah. Have you ever been successful in getting them to remove their indemnity provision?
No.
Yeah, good luck. Right? All right, we'll talk about that more in just a minute. All right. So, this is take this home to all your contracts folks. You're training up new folks. Remind them if they get a contract like the hypothetical I just showed you. The question is, well, why isn't the contractor instead agreeing to indemnify us? Right? I really think that's the appropriate starting point for any contract drafting with respect to a relationship with an independent contractor. It's usually the case, organizationally, setting aside legal principles, that when we go out to hire a third-party vendor, right? Yeah, we're looking to find a different price. Maybe somebody could provide different services. Maybe somebody's has more flexibility in scaling to our needs, etc. But underlying that, what we're really also expecting is to be able to transfer risk from doing things ourselves to using an independent contractor, right? And if the purpose and scope of that arrangement, right, is to hire and pay the contractor to do the work and be responsible for the risks, right, then we should be rejecting their request for indemnification. From their perspective, I can assure you, it's kind of it never hurts to ask, right? We might as well, right? Why? Let's not presume and start, unbundling and taking things out that would be for our benefit. Even, sophisticated contractors who are dealing with public entities, right? They know from prior negotiations with other public entities that they'll probably have to negotiate or remove some indemnity provisions, but they're going to look at each transaction afresh and they'll send you the boilerplate language, right? So instead, your entity should be getting these protections from the contractor. Building on Jeff's question here, in practical terms, I think a little bit of how good the indemnification is that we can get, or the one that we might have to give, ultimately boils down to the golden rule of indemnification in terms of practical contract negotiation, and that's, the party that has the gold rules, right? Right? What you're able to require or get with respect to indemnification, that can depend heavily on your leverage. If you've got the money, the approval power, and many options, you've got the gold. Who agrees with that sentiment? Public entities generally have the money, approval power, and the gold. Doesn't always feel that way. But yeah, but in terms of dealing with an independent contractor, I encourage you that would be your starting point, right? If that's the case, you want to require an indemnification. I'm sure, how many of you have your own templates or forms that you use with consultants and vendors? So you've got your own standard indemnification language that you use. If you're looking for another sample, at the very end of my presentation, there's one as well, which is very kind of plain vanilla, middle of the road indemnification paragraph. Okay? Now, on the other hand, sometimes somebody else has the goal, like a railroad or the state or some federal granting agency, and they want indemnification. So, to go to Jeff's point, how many of you have tried and been successful on the hardline approach? We don't indemnify, we never indemnify, we can't indemnify.
We take a hard line.
Good. Okay.
We're not always successful,
Yeah.
but we try to take a hard line.
Yeah, the two constitutional provisions that support you in that regard, and it's beyond the scope of this presentation. If you want more resources on it, you can certainly email me and I can send you more information about it. But there's two constitutional provisions that come into play. One is a prohibition, right, upon providing aid to or assuming the liability of a private entity, okay? And so there's been a lot of legal debate about what's the scope of that, right? But in its purest form, it's the argument that that constitutional provision says we as a public entity, right, cannot assume a financial obligation that belongs to some other entity than ourselves, okay? And the other one is the Tabor Amendment. Boy, I'm dating myself, but Tabor was passed like 30 years ago, 35 years ago. It was the year I first started practicing public entity law. I said, this is exciting. And we still don't have, 30 some odd years later, a case directly on point, answering specifically the question of whether kind of a generic indemnification clause in a services contract that doesn't have a time limit to it and thus appears to be open-ended, whether that would be a violation of Tabor. But the argument under Tabor is, if I sign a contract today and agree to indemnify you, the vendor, against some potential future cost of a liability for which the indemnification provision is triggered, am I not assuming, right, a financial obligation in a future fiscal year for which I have not appropriated funds, right, or gotten voter approval, right? So, and from a contract drafting standpoint, the most common tool to address that issue is what? The non-appropriation clause, right? We include a boilerplate language in there that says all future financial obligations of the entity are subject to, right, future budgeting and appropriation, and if we don't appropriate, then there's no obligation. To be fair, let's put on our devil's advocate, look at it from the vendor's perspective. Are they comforted by that? They say, oh, city, you need to indemnify me, but you got this weird language that says that if there's ever an indemnification obligation, you're not going to honor it if you just decide not to put money to it. Not so comforting. But you can use the hard line if you can, because that's what the Constitution says. Yeah, someday we're going to have, so I think entities take differing approaches on that. It's an open question still, ultimately, in black letter law as to whether that would be a violation of the Tabor clause. But I think it's a strong argument in your favor, and certainly one that if you have to get through that, the only way through it, that's straightforward, is to have the non-appropriation clause. Anybody have further questions, thoughts on that concept? Okay, now if you do have to give an indemnification, it never hurts you to negotiate. Some of the things that I see in particular is if you're confronted with an indemnity clause, look to remove exposure to risks that are clearly outside of your control. Look to narrow, right, the scope of the indemnification provision. Two areas that I see commonly when we're asked to review contracts is, contractors who you hire to come on your property and do something that requires the use of hazardous chemicals, they ask you to indemnify them against hazardous materials and pollution type risks. It's like, well, you're the ones who bring the stuff here and using it. Why should we indemnify you? And then who loves software contracts? Who loves software contracts? Yeah, software contracts, they're the smart ones, right? They got this software. And then they say, we'll sell it to you for $1 gajillion in licensing fees, but it's our property. Oh, but by the way, if we get sued for some intellectual property risk because we stole somebody else's software, you, the one who's using the software, you'll indemnify us, right? Wrong. Yeah, so that's one of the most common ones I see as well that you'll definitely want to battle against if you ever have to deal with that issue. All right, let's turn the page and talk about indemnification and insurance. Broad theme, of course, every contract, in my view, ought to have appropriate insurance provisions, including at a minimum an express requirement that the other party carry the appropriate insurances, that your entity be named as an additional insured, that they provide you with a certificate of insurance. We're going to talk a little bit more about additional insured, but as we know, like in certain types of situations, the insurance policies will automatically cover you, right? Trigger automatic additional insured status if it is a insured contract. Backing up a little bit, I was, for a long time puzzled about the idea, well, wait a second, I got a contract that says they'll indemnify me. and I know they have insurance, but doesn't their insurance have a contract exclusion? So what am I, well, yeah, but, policies say they don't cover contractual liability except for insured contracts, right? And that's how you get to the concept of automatic or blanket or additional insured. That's where, from a best practices standpoint, you're going to have to start unpackaging things to make sure that your entity, right, if you're asking for indemnity and additional insured status and they say, well, you're automatically covered, right? You say, well, show me the language that confirms that, right? And give me a certificate that confirms all the coverages are in place. You get to automatic additional insured status a couple of different ways. I'll show you, in terms of policy language. There's CIRSA's example, the yellow highlighted. If you're a CIRSA member, it's covered in the who is a covered party. And we say a covered party includes any organization or person to whom the member is obligated to provide coverage, right, because of a written or oral contract with some limiting language that AI status is only for damage or injury arising out of the premises or operation of the member, right? There's the ISO version of that. I'm not sure which form it is in terms of the continuum of ISO forms, but same kind of things. It includes a person or organization who by written contract is included as an AI, but only for tort liability, right? And only for tort liability that's caused in whole or part by the named insured's acts or omissions in the performance of ongoing operations. A couple of interesting points there. It says ongoing operations, right? Way back when, the ISO forms didn't have that limiting language, right? So if you're doing a contract, what do you want to include in your required insurance coverages, particularly for construction contracts? You want to make sure that it says you will carry, right, liability coverage, and shall be no exclusion for completed operations. And if it requires an endorsement to get that protection, then you want it. What's a hypothetical as to why that's important? You hire a company to build a retaining wall for you, right? They finish the work, looks beautiful, you sign off, issue the final payment, still looks beautiful, but after they've left the site, complete all the work, 6 months later the wall collapses on somebody's car, right? Well, you have coverage, right, if there's no coverage, we have any financial recourse to the insurance as AI if completed operations coverage was not there. No. Right? You want their liability coverage to respond to that later incident after they've completed their operations. Okay. Too much for this presentation, but just as a general concept, from an AI's perspective, it's not all that apparent, but the older the ISO form, the broader the protection for the additional insured. And that usually relates to the language about causation. Okay, it used to be that AI status was conferred for any liability arising out of the named insured's work. That's pretty broad, right? Now it's language like what's noted here, right? Which is the language is caused in whole or part by, right? Going back to my who has the gold slide, if you have to give an indemnification and you're looking for language that tries to make it as tight as possible, I suggest that folks look at language like, well, if we have to, we'll agree to indemnify you, but solely for bodily injury or property damages claims, solely to the extent they result from the actual negligence of our own public entity officers or employees, and try to resist anything broader than that, or as Jeff suggests, resist it altogether if you can. Okay? Just the broad points about what AI status provides, of course. It reinforces the contract indemnity, serves as a back up to the contract, provides the financial resources. How many of you deal with kind of what I call low-level contracts with sole proprietorships or individuals? And I think I mentioned yoga instructor, but those kind of people, or maybe vendors at your festivals or fairs or something like that, and they come in and they say, I don't have insurance. You don't have to answer it here, but do we bend on that? No. Do we not bend, For CIRSA members, we have an insurance product that might help address that situation as well, our special events coverage. But, look, particularly if they're doing hazardous work, if they're going to hold themselves out to walk and talk like a vendor that's selling services and products to public entities, I'm preaching to the choir here, but it's fair to tell them that you got to walk and talk like an independent contractor and have insurance that protects us, right? Benefits of AI, of course, give direct protections under the named insurance liability policy, such as the right to immediate defense rather than incurring your own defense costs and requesting reimbursement later. You get the right to indemnify, right? So those are a couple other thoughts. If you're requesting additional insurance status for your public entity, well, we'll talk about certificates in a minute, but how do you absolutely know that you're going to be an additional insured? You can get a certificate, they can tell you, they can send you an email, they can do all that, but where are you going to find the real answer?
Get an endorsement.
Yeah, in an endorsement or a policy, and you want to read the actual policy language. And you all have those, you know, you love reading those policies and getting those from vendors and letting them stack up high on, right? So you want to make sure, if you're asking for AI status, do whatever diligence you need to do to confirm that the contractor's coverage actually allows it. Necessarily read their insurance policy and look for potential limitations. Here are some of the traps, right? Sometimes the language can get a little wonky and they'll say AI status is conferred only if endorsed. Then you get the endorsement. Covers only written contracts. Well, that just kind of ties things up neatly. That, in my mind, is the reason to make sure that your contract, right, includes good express language on insurance requirements and on required AI status, so that somewhere down the road, you know, not in the contract office that wrote the contract or in the underwriter's office, but in the claims department, the frontline adjuster who's looking around to see who's supposed to be picking up this responsibility of this claim can pick up the contract and see very clearly, yep, that city or town, they're AI and they're protected, and we got to handle their defense in this claim. Okay. Other things to recognize: how many of you see contracts where the vendor says, you know, notwithstanding any other provision, the maximum amount of liability is the maximum amount that you pay us? Or, all the time. All the time. Yeah, if you're getting AI status and that language isn't carefully crafted, right? No matter how much coverage they have, the amount that you're actually going to get, right, through the insurance is going to be limited to that lesser amount. Because, for example, make sure I'm going the right direction. I don't know if my little red radar works, but in the very bottom right-hand corner, the limit of insurance provided to AI will be the limits to which you agree in the written contract, right? Or the policy limits, whichever is less. You want to be careful about that issue. Okay. Just a couple of tips running the other direction. If your entity is asked to name another party as additional insured, a couple things. As I mentioned earlier, first look at the question of whether you actually have the strength and negotiation leverage to reject that request. If you're absolutely stuck with it, use as narrow language as you possibly can. Try to tie your obligation, if at all possible, to nothing more than what you're obligated for under the Colorado Governmental Immunity Act. You may decide even narrower than that, right? And then there's a couple of consequences in sharing your coverage with an outside party who's an AI. Of course, you're sharing your coverage and your coverage limits with them. You may also be sharing your limits with an entity that's not subject to the Colorado Governmental Immunity Act, right? So if you're sharing your coverage and you know it's a premises liability claim, we know as a public entity that our maximum exposure is the per person and aggregate limit under the CGIA, right? But if that other party that we're extending coverage to doesn't have that, who knows, right, what the exposure is that we're picking up as well. And then depending on your insurance, the loss history related to the loss payment on behalf of the AI becomes a loss payment on your own loss history. Okay. Last thing on additional insurance, you know, where does all this leave us with regard to our original question? Yeah, you can agree, right, to overly broad indemnity provisions, but please don't, right? Make sure also that you avoid broad or inartful language. If you're getting AI status, you know, the other thing you hear, who hears this from vendors? Your indemnity language is too broad. I'd like it just to say, we'll indemnify you to the extent we have insurance. Some people say that, right? Yeah, well, you have every right to bargain for, as a matter of contract, additional protections against risk that aren't covered by insurance, and you should, right? a lot of times you'll see a vendor propose, we will indemnify you to the extent arising out of negligence. Well, is negligence the sole measure of fault? There are other bases upon which someone could be at fault legally. Sure, intentional misconduct, willful and wanton conduct, intentional torts, gross negligence. Right, so use language there that will protect you as well. And then finally, for construction agreements, just recognize that there are anti-indemnity statutes in Colorado, right, that basically disallow a party from bargaining for indemnity against its own negligence. The statute that I mentioned here, 1321-115, is related to construction agreements, doesn't apply to other types of agreements. There's another one, and I'm sorry I didn't put it on the slide, but it's Colorado Revised Statute 30-50.5-102, and it's an anti-indemnity statute with respect to construction professionals. So this one that I mentioned here is for the contractors. The other one is for the professionals involved in the construction process, architect, engineers, others, same kind of concept. You can't attempt to hold them responsible through indemnity for more than their proportionate share of the fault. Okay? All right, any questions, thoughts on that stuff? All right, let's talk about certificates of insurance, which could be its own presentation, but given time limits, I just want to hit a couple of highlights. And it's like, my original reaction to certificates when I first started getting into this, I was like, well, what's up with these things, right? Because you get this, everybody exchanges all this paperwork, and then what do we do with it, and who looks at it, what does it mean, and does it have any value, right? And I always loved, I'm getting ahead of myself here, but I always loved, it's got all that stuff on page 1, but there's room on the certificate for, additional language, and it's like, there's that page. You can put whatever you want on there. And a lot of times, that's the second page of the certificate if you've never seen one. This is where people get to list additional things. And people say the darndest things on the second page of the certificate, right? But what's the point, and why are they sent and what are you looking for? And there's standard policy language, contract language that everybody seems to have some form of this, right? Prior to starting work, the contractor is going to afford you a COI, that certificate names you as a certificate holder, and you got to provide written notice if any of the policies are canceled, etc. So let's break a couple of those issues down. All right. Has anyone ever tried to sue the issuer of a certificate of insurance directly because the certificate was wrong? Can't do it. Can't do it. Under Colorado law, the certificate of insurance is not a policy and it's not a contract. Right? It's simply a document acknowledging that an insurance policy has been written. Thank you. Well, that's good. Right? It provides information on a party's coverage, usually the things that are listed there, but it's purely informational. Colorado Supreme Court looked at this in 2016. I was happy to hear it was Pinnacle and now CIRSA. But, it was helpful to all of us in the public entity world. Doesn't matter. Sometimes we hope it's somebody else who's, on the cutting edge of the law, but it helps us, the rest of us, sort these issues out, right? The certificate is purely informational, confers no rights on the certificate holder, right? And we knew that. It says so right there. That's like that's the discomforting piece of the certificate, right at the top of the page. This certificate is issued matter of information only, confers no rights upon the certificate holder, right? But nonetheless, it's a useful document, right? Some things to look for, common issues with respect to your contract that you set down next to the certificate. Make sure there's proper alignment between the insurance requirements of the contract, right? So does the certificate and what they're showing on the certificate line up with the types and limits of coverage that you've listed in the contract? If not, you want to reject it and send it back and tell them, hey, we got to get this in order, right? Other technical defects I mentioned, completed operations, cancellation, and notice provisions. Just want to point out a couple of things on a few of those. With regard to types and limits, one of the most common things that we see in doing contract reviews for our members, particularly around the larger construction projects, is the question of whether the coverage, the mid-level contractor, mid-level size contract, and we've negotiated and you decided that $1 million per occurrence is okay. Right? But what if they're a contractor doing work several locations around the state? Right? Is the $1 million enough? Have we given that attention? Right? So we encourage that if that is the concern that you have, that in the contract language you require that the liability coverage apply on a per project basis, right? And then that's going to translate to the certificate, to the little bitty box on the left-hand side, a little ways down underneath the types where you can actually click, right, the correct answer or the correct item on whether the limits apply on a project basis or not, okay? So. Notice of cancellation. This is another one where we, from an underwriting standpoint and from our perspective in issuing certificates, we've wrestled with this issue a lot over the years because contract language doesn't always seem to line up with what policies say about cancellation. So this is the older accord form. It says, as respects your relationship with a vendor, on day one when you sign the contract, they provide proof of insurance. We all feel pretty confident because it's day one. And are we confident on day one of next year that they're still going to have coverages? We cover some of that risk by saying in the contract that, we must be given notice of any non-renewal or cancellation. But what does the policy really say about how the insurer, the one with the real control, is going to give notice to people? So that's the old accord form. It used to say, should any of these policies be canceled, the issuing insurer will endeavor to mail 30 days notice. Anybody know what endeavor means?
We'll try.
Try to.
We'll try. We'll endeavor. Yeah, it's kind of like I tell my relatives that sometimes about their gatherings. I will endeavor to make it to your house, this weekend or something like that. Yeah. So there's not a lot of teeth behind it, right? Which is good for me in that situation. So, that's where I kind of left you on that issue, and that's why we had these negotiations over the endeavor language, and even CIRSA's. We have various templates that we provide to our members. In our contract template, we used to give people contract language that says, in your contract, expressly say that if the certificate uses the phrase endeavor to, it shall be deleted from the certificate. But that just kicked the issue down the road a little bit because then the producer who is issuing the certificate says, well, I can't do that. It's just our company policy that we can't do that. So the more current version looks like this. It says, should any of the described policies be canceled before the expiration date, notice will be delivered in accordance with the policies. Are you all comfortable with that? Do you feel like reading the policy provisions when you read that? As a matter of contract law, just recognize that what that language is saying, it's not saying that you as a certificate holder are going to get the same notice, right? What it means is that notice is just going to be given to the pursuant to the policy to whoever under the policy is entitled notice, right? So if the policy simply says notice will be mailed to the first named insured and that's it, that's all that's going to happen, right? So, and there's actually case law on this as well, right? It says the language in the certificate here about notice, it's not essentially conferring on the certificate holder all the same notice benefits as the named insured has. Rather, it's saying the whole question of notice is only going to be resolved by the language in the policy. One way to solve this, and I guess it depends, is partially solve it because it depends on how much confidence you have in your counterparty, is include additional contract language, right, that says the other party, irrespective of what their insurer is doing, they have a contractual obligation to specifically give you notice, okay? The special provisions box, you all know about that. That's, it can have relative degrees of importance depending on who's looking at it, but you want to have that language fit neatly and nicely into whatever contract. This is an example just from us at CIRSA, where one of our members was required to provide, I think it was AI status for the owner of a parking lot, and the town really wanted to use that parking lot for the 4th of July celebration, so they didn't hold a lot of gold, and they agreed to name him as AI, and so you kind of have a fairly precise prescription of what the insured contract is, okay? Lastly, just want to talk about remedies a little bit. As I mentioned, the remedies boilerplate's usually at the end of the contract. Usually when you get to that point, and you're exhausted, you're reading that boilerplate, you go, everything's great. This will never be an issue, right? Let's just last 3 pages. Let's get this over with, right? Just be very careful because that boilerplate, right, you want to make sure actually those remedies provisions are acceptable because a lot of times remedies provisions can fall into some troublesome categories. Now, before I get to the actual language you'll want to avoid, the other thing you probably want to avoid is contracts that have little or no language at all regarding remedies, okay? And I'll mention why in just a second. You also want to avoid things like waiver of remedies, right? Waiver of subrogation, caps on damages, or waiver of certain types of damages, and then more legalistically specific language that limits, by contract, your statute of limitations to bring a claim, right? Or puts other limits on the forum where you can go to get legal relief. I say all this all in view of a larger principle that's lost. We're still, public sector is a huge part of the economy, but we're still just a part of it, right? And I think in the world of contract law, the law, the judicial way of looking at this is the remedy for contract problems is dollars, right? But for public entities, that often is not the most satisfactory remedy. It's like, we have a community that needs these services or these products. What we really want is performance a lot of times. Yeah, we'll take the money later after you get the job done and we total up what our damages were, right? But public entities, in my view, are particularly interested in remedies that help get the contract performed. So be wary of provisions that waive things like injunctive relief, because that's probably the first thing you might ask for, right? If someone's dragging their feet and you feel like they've breached their performance obligations, as long as you still trust them enough to get the job done and you don't want to kick them off the job, right? You may be seeking injunctive relief. And then who deals with liquidated damages? There's a balancing act under the law. The liquidated damages is basically the amount that's owed for every day that a deadline is missed under a contract, right? There's a balancing act because the law does not allow those to be what in the eyes of the law is punitive or a penalty. But on the other hand, you have a right to ask for them. They just have to be a reasonable, right, estimate of what your actual remedies might have been, your actual damages might have been. Make sure you hit that sweet spot and resist vendors who are saying, well, that's really money out of my pocket, and the liquidated damages, it needs to be really low or I can't do this job. If you want to walk and talk like a public entity contractor, then you ought to agree to reasonable liquidated damages, okay? Be careful of provisions that waive various categories of damages. You've seen all that boilerplate. It always seems to be in capital letters. Yeah, and I'm still tired when I'm reading that stuff, right? I'm not going to read on it. But, we hereby waive consequential damages, punitive damages, lost profits. Good idea? Bad idea. Now, some damages, you may not have a right to recover anyway. Lost profits, for example, are pretty significantly limited, but in certain cases you might recover them, and in certain cases you might want them. I'll give you an example. You got a park or rec facility that's fee-based, so revenue for that facility comes in from user fees. You do an agreement with a contractor to do some repairs, but they're the ones that break the water line and flood the community facility or rec center, and nobody can use it, and you lost fees, right? Now, you might have some business interruption coverage that might cover that for you, but do you really want to go after the person at fault, right, to get them to pay for the lost profits? Yes, but if you've waived lost profits in the contract, then you've given up that right, okay? Waiver of subrogation, it depends on the insurance policy in play, but most commonly, right, you do have a right to waive subrogation if you choose to do so, but only prior to a loss, not after it occurs. In the area of waiver of subrogation, I do point out one other thing regarding public entities. Whether you're self-insured or in a pool, I think a waiver of subrogation has a little bit more of a public accountability piece to it, because if you waive subrogation, you may be depriving your own right, or another public entity, quasi-public entity like a pool, their right to actually recoup public funds from the at-fault party. If you've got a large retention and the whole loss was in your retention, you waive subrogation, and then you've lost your entity's right to recoup from the at-fault party as well. Okay? Damages caps, be careful of those. I mentioned that piece earlier, right? In addition to, it may pull down the limit that you can get from insurance. There's often really no good relationship or explainable relationship, as to why the vendor says I need a low damages cap and the actual risk that they're creating. Okay? And then lastly, timing and form. Have you ever seen that contract that says, notwithstanding any other provision of law, you, the city or county, agree that any legal proceeding must be commenced within 12 months after completion of the work. Yeah. Well, that's much shorter than the statute of limitations in Colorado, for example, for bringing a claim against the contractor for building the retaining wall, right? And what if they completed the work and left on day one, but the wall collapsed 13 months later? By contract, you will have lost the right to go after the contractor, even though the statute of limitations that have otherwise applied probably would have given you the ability to sue them for the defective wall that they built for you. So those things are all artificial attempts to shorten what the legislature has determined, right, is the appropriate length of time to bring an action. And we know sometimes the vendor says, well, if I don't have this, then I face unlimited liability. Who agrees with that? No, you don't. You face the liability standards and timelines that are determined, right, under this body of law that we have here in Colorado. And then lastly, arbitration. Arbitration is a good vehicle to perhaps more efficiently and more timely get a dispute resolved, but it depends, heavily on the situation, depends heavily on whether you want to put your fate in that process. So if you have an arbitration clause, I suggest trying to have it both ways. So we agree to voluntarily participate in alternative dispute resolution. But if we don't do it within a certain time, or if we can't agree upon the process within a certain time, then we reserve all of our legal rights. Okay? So I hope this presentation's been helpful to you all. Just a couple of concluding thoughts on best practices. Make sure you give your risk transfer provisions the time and attention they deserve, as you've done, as you see by the show of hands. Develop your own forms. Insist that they be used instead of contractor forms. Be wary of a boilerplate. Make sure you have the appropriate insurance provisions with appropriate limits. Utilize your team of experts in risk management and your legal department in drafting and reviewing and negotiating your risk transfer provisions. And as necessary, I'm going to leave on a high note, as necessary, you're going to ask for and review actual insurance policies and endorsement language to make sure you're getting the protection you need on behalf of your entity. So with that, I'll open it up for any questions, if there are any.
I just had a quick question.
Yeah.
Often we get certificates of insurance that say if required by contract, yeah, we're doing it on a purchase order. So we have maybe not a contract in place, we have them remove that language. But I know the additional insured status is contractor agreement. When you're not working with the contract and it's just like a purchase order, does that still apply?
Yeah, you're saying that you're dealing with a vendor and you want to be AI on their coverage?
Yeah, but they say only as required by contract, but we're doing it on a purchase order.
Yeah, but you still want it?
Yeah, we want the additional insured, we want them to provide us,
Yeah.
make us additional insured.
Yeah, I think you want to include language on what risk you want protection against. You want an indemnity clause. In the PO, is there an indemnity clause at all? Or
I'm just talking about the certificate of insurance.
oh, I'm
That
sorry.
in the additional insured, you know how they like to say.
Yeah, you could ask them to
we need
delete the
provide-
phrase if required by contract, but what's going to control is the underlying policy anyway.
Okay.
Yeah, so you could delete that language, but if you pull the policy from whatever carrier and it still says that AI status is only conferred when required by contract, then you will not have improved your lot. You still need to have an underlying contract.
Right, we have an add or agreement.
Sure. Yeah, contract's a contract. In my world, you just have to prove up the fundamental elements of a contract.
Right.
Did we exchange consideration, right? Was there a meeting of the minds about what the contract was about?
Right.
Was it approved by people in authority? Then you got a contract. Any other questions? Thanks so much, everybody. Let's turn it back to
Well, thanks, Sam. That was a great presentation. So now if we are unsuccessful in transferring our risk, we'll lead into the next part of our education session today. Tom Hebson from Tristar is going to talk about our total cost of claims, whether they're caused by us or by our vendors.
If I just did this forward here. Are you gonna? The way out of that is you need attorneys at all times because there's a lot of crud that goes through a contract. I didn't write a disclaimer because that would probably take about 6 slides because some lawyer wrote it for me in my company. But generally speaking, you know, we disclaim that this isn't always Tristar's opinion. What I say up here may not be Tristar's opinion. So just come back to me, but you're gonna hold me harmless and indemnify me for anything that you come back to me with. All right? So I want to talk a little bit. How many people here know the difference between ALAE and ULAE? I'm waiting for the brokers to definitely, yes, I know this. No. So just a few of you. It gets muddled everywhere. It seems like, is this or is it that? Contracts actually specify. So your insurance contract, when you look at your insurance carrier contract, they usually tell you what your ALAEs that's included or has to be approved. So I use, everybody uses the iceberg, right? And I didn't put any numbers in there because it varies so much. But there's so much cost in a claim that's underwater. It's not only the cost that you're paying as a provider for the workers' compensation, it's the lost time of having to, either put people in for overtime or put other people where you're just losing productivity. So all those things get pushed down under the water. So, how many of those things are the ALAE aspects of handling a workers' compensation claim? And I'm just going to talk really about workers' compensation today. Okay. So let's talk about ULAE, or unallocated loss adjustment expenses. It's really easy. Just think of it as it's any expense that's hard to allocate to a claim file. Because there's not like a specific dollar amount that says, oh, I paid John Doe's benefits $100, I'm going to put that, I allocate that right to the file. And if I had some kind of medical practitioner that looked at the person, that goes right to the file because it's allocated to an individual claim file. So unallocated is everything else basically that goes on in the claim handling process, that's salaries, expenses not directly attributable to file, and of course any expenses that aren't allowed by a carrier or state. How are they calculated? Salaries, pretty easy. Direct overhead, so that's benefits and office space and things like that. And then the corporate overhead, people like me coming out and doing different things, I'm the corporate overhead on cost. And that's all unallocated. And profit, of course, you got to put some profit in. We run for-profit business. We do anyway. And then just from that standpoint, the type of contract, how many people here buy a life of file contract for your claims? Or life of claim? How many people buy a life of contract TPA service contract? Do you know the difference? I'm thinking almost all public entities always seem to want to purchase a life of contract. And generally speaking, those are a little bit less than a life of claim, because a life of claim means that you're on that claim forever as the TPA or claims adjusting company. So the allocated, and this is pretty easy. So I'm going to take like pages. You probably get pages in your proposals from TPAs. And they have like standard things, we call them preferred provider thing. Medical bill review, that's usually a dollar amount of, some kind of dollar to review a medical bill. The PPO savings is then, how much savings did you get based on that billing from the network? And so I do that. Case management, UR is utilization review. Nurse triage, everybody know what nurse triage is? Okay. Peer review, IME, so independent medical, pharmacy, MPN, so we've got different states, so there's different ways to access care. And then others, we have attorneys, of course, then investigation through Robert and Andrew's company, expert services, so there's reconstruction that may go on in the claim that you have to have, surveillance, durable medical equipment, subrogation, these things that can still be allocated to the file. So I'm not going to bore you with all this, but I just pulled you. This is ALAE wording from an excess carrier. Everybody here have an excess workers' compensation, or most of you do? So this would be kind of what they say, and they always say, and then it's kind of then, and whatever we approve So I mean, if you've got something strange and you're working on, especially catastrophic claims, that's coming through, is that going to be part of the allocated? And what it means is it's when their insurance engages, it's usually the loss dollars, so the actual loss dollars, but it's also the ALAE that also it reduces the attachment. So basically is eroding that so that your attachment comes down as aggregate of claims are paid and allocated loss adjustment expenses are put into a file. It's a tough thing, but the idea is that the excess carrier says we're going to count allocated loss adjustment expenses as loss, and so it does. So if you have a $500,000 retention, you have $300,000 of direct loss, and you have $300,000 of ALAE, you've then penetrated into their layer, and so you're able to do that. In the old years, that contractual risk transfer may have been that carriers, they actually did a pro rata ALAE. So if you had $300,000 of ALAE, it's whatever the pro rata of that total loss is on your financials, and it's on then the carrier financials. They don't do that. I ask a broker here, I don't know if I've seen that lately. Maybe a reinsurance contract out there does, but generally excess contracts don't do that. So, the whole idea about ALAE, it's really to get people back to work, right? We've got to be caring, talk about, how are we going to get a person back? Poor Joe suffered a loss, let's get him back because his family really wants him out of the house or something. But, the whole idea is that this continuum, if done right, this is one of the best ways to get people back to work and make people feel like they're wanted in the workplace. Nurse triage, it's a caring, basically a caring phone call. Early intervention, getting into it right away. What happened? Let's get in there, get the initial contact. Let's find out what's going on. Let's make sure the family knows what does. Let's understand the process. Case management, help guiding you through when you do need the care. And utilization review, understanding, when to use that utilization review, and then getting people, the right meds or maybe no meds at all, which is really important. What happens though is there's a lot of things that get involved in every one of these steps. So I like to, let's just start with ULAE a little bit. Does everybody know how much adjusters get paid? I don't think there were any other TPAs in here unless I missed somebody. Kind of average examiner, senior examiner, probably, we'll look at here. So, the supervisor, okay, these are averages. So $105,000 a year, that's, average supervisor. They oversee approximately 900 lost time claims. So that's usually 6 adjusters, 6 examiners. The senior examiners in today's world, and this might even be a little low today, I think I did this about 6 months ago, so it's a ticking clock here. So they're about $90,000, examiners $75,000, and you see this everywhere. Denver's not the cheapest place to live, so you kind of see some of that here in the local area. Medical only, and then their support staff. And so you've got all these people, these numbers over here, kind of what they handle from a transactional basis. So let's down. So we've broken this down. So we've got these folks here. This is how it breaks down, and I don't know if is there? Oh, yeah. So I don't know if it works, but this is how it breaks down on a per claim. So if you took, 150, 75, that's $500 a claim. That's just the base cost of having an examiner on your payroll. So then if you load it, and so there's different ways of loading, profit, direct overhead, corporate overhead. I'm just using a 2 times factor here. That could be in low in some areas, could be high in others. So if you load that, then that supervisor is now $210,000. So as soon as the door opens, $210,000 for the supervisor, senior examiner, $180,000, wow. The numbers next to it are now the loaded numbers. So if I want an experienced examiner on my program, so I'm going to get a senior examiner. You start out of the chute, and there's other variables I'll talk about. $1,200. It costs $1,200 a claim for that person to be in the payroll. So, and this is where I'm getting into the allocated. So if you do this math here, okay, so the supervisor, if they're overseeing just one person, one of their 6, it's 17% load here. So they're $40. So $40 in any given thing. Senior examiner, let's say I want to use a senior examiner, so they're $1,200. And I'm going to use probably some support personnel here. But I'm just talking about lost time right now. So, what does that add up to? Well, the total per claim cost, if I use a senior examiner, is $1,251 per claim. And this is just breaking it down on a per claim basis. So I see, as a TPA, I probably have proposed less than $1,251, but I know that, my competitors did. And I always scratch my head and say, at what point can we regain that money? Because we're a for-profit. I think I said that at the beginning. We're a for-profit company. And so we have to make a little bit of profit in order to maintain our service. So so it gives you an idea. That's just a quick benchmark. And we'll talk about same thing, examiners. So some people are, you see proposals and it's like, I'm going to get a senior examiner is what I want, but I actually got an examiner price. So am I really getting the examiner or am I getting the senior examiner? And so med-only adjuster, $194. I think that's really pretty close, I think, in the business. When you look through everybody that I compete with, pretty much $185 to $200, $205 per med-only. So what are the impacted claim durations? So that's the biggest variable that we run into. And this is going to be part of, when I'm getting to the ALAE, and I apologize for that, but I really want you to understand what the base costs are and then where we make money as a TPA. I'm giving it, see, this is probably not the opinion of my boss, so you probably won't be up here saying, don't give away those, that information. But if you're going to make a good buy, you need to be informed. And so for us, the basic things you need to look at is how durations can impact that. So I had that at 150 caseload. It gets that $1,200. Well, what if they're able to close 30% of their files every year that they get? Well, then now 30%, 150, we'll just say it's 200, close enough. So now they can handle 200. So that really reduces their per claim charge that's on our books. And that really helps. So duration is something that we should always look at. Are we, is our examiner at 100% turnover, 50% turnover, or maybe they're only doing 10% more than 150 on an annual basis. And return to work plans, I wanted to put that in there because if you have return to work plans, one of the best ways to improve durations, working with your claims administrator, but also working in risk management, is to get people back to work. That is probably one of the most important things. So what do you look for proposals and loss runs? Are the claim costs too good to be true? I'm going to get a fee per claim that's $750 for a lost time claim. Probably too good to be true, unless you just have a fabulous program that has incredible back to work and very short durations. Are services separable? How many people put their proposal, your RFPs out, and say, I want a proposal for a combined program, so I want to be able to the claims handling, plus I also want you to do the managed care side. Or do you say, I want a proposal for just managed care and one for just claims? See if these are separable. If somebody says they're not separable, it definitely is a lot harder for us TPAs to do it, but don't worry about asking the question, ask the question. Caseloads and durations, this is the other thing. How many people, I put 150 as the caseload. How many people want to see their TPA running at 150 caseload for their lost time adjusters? Probably, in today's world with so many regulations and that we're working with in different states, you might want to consider going down to 135. Maybe even 125 for certain claims. You've got to make a decision whether you think 150 is doable or not. And I'm not saying that adjusters can't do it. Examiners they're very good examiners that they could probably handle 200. But on the averages, if you think about it, and everybody knows about the turnover in this business, you really have to look at, what do I want as an organization to best service when I do have an injury? What do I want to see? as far as servicing that injured employee. You know, utilization review, you know, make sure you understand what you're driving into utilization review, because there are companies that have overused that in the past, and it's expensive. It's an expensive ordeal. Repetitive or unusual nurse case management charges. And I have an example here that's just incredibly bad. It's amazing they got away with it. Gross versus net savings. So, you know, there's certain times when you get a proposal and it doesn't say gross or net, so it's anyone's guess of what percentage of the savings is based on. So make sure you tie down those savings and what type of savings is it. So, and I said that anything less than 1,000 per lost time claim, just make sure that you understand how they're getting to that. You know, how did you get to that number? Duplicate bills. I have also an example of that as well. Is everybody medical? So you're getting your bill review system. It's, you know, some people have it. It's like, you know, I generated the bill, received it at the doctor's office, but they didn't really receive it, but passing in the mail again, another duplicate bill was sent because it hadn't been paid. Well, they actually charge, some companies charge 2 times for that, where other companies say, no, a duplicate bill, no, we sent it once. Unless there's a change in coverage or, you know, what medical care coverage happened, you should never see somebody charging for duplicate bills. Use of defense counsel. You know, I don't know, does anybody have, you know, brothers and sisters sometimes? It's like, oh, my brother is a attorney who almost knows workers' compensation, and we're going to make him a defense counsel. And, oh, by the way, they need a new boat, and they need a new car, and a new house. And so, you know, we see where some defense counsel can get running. And generally speaking, it's some kind of corporate relation, like, you know, oh, this corporation has done a lot in the community, so we're giving them our defense work. And, you know, it's not that you don't have to, just make sure they understand this business. It's a very complicated business. So, and this is, you know, again, these are the things that you got to look at, and I kind of cut this a little shorter, but because I'm here, you know, I don't want you to be here forever. So here, you know, nurse case management. Has anybody had a claim convert from med only to indemnity? So it's either like 6 months or dollars, you know, whatever it is. If I've paid more than $5,000 in medical costs, I'm going to convert that now to a lost time indemnity claim. Sometimes what happens in that conversion is it's like, oh, I'm going to reassign a new nurse case manager. Nurse case manager may just be a general one, maybe a telephonic nurse case visit. But just look at it and just make sure that they don't automatically just appoint it, especially, I'll show you again another example of that. Unusual request to replenish claims funds. Has anybody ever had that where you walk in on a Monday and it's like, oh, by the way, we need $100,000 put into our claims fund because of this, you know, ALAE cost that just came through the door, like a defense cost or something. You know, gross or net on unbundled proposal. Again, you know, when I said that, there's nothing wrong with asking that. I think that's just good fiduciary responsibility of any business owner, or in this case, you know, from public entity risk management. And then, you know, our duplicate bills, defense counsel, aggressive. So the first one, this one just came up about 6 months ago. We had won a piece of business up in the Northwest, and the TPA, when we were transitioning, so we started handling claims, and you go through a transition period to pick up the tail because we're all life of contract on there. In the matter of 3 months, they had $260,000 in nurse case manager fees assigned to 40 files. And the problem is that who's going to question them now after the fact? So they put a request in for $300,000 to put in their claims account so that they could get paid. Just a tremendous abuse of the system. And this is, nurse case management stuff happens, it's happened for years and years and years. I go through a lot of insurance carriers that are not in business any longer for it. Med-only claim converted to indemnity. This is where we were auditing a file, and we saw that $1,130 at the conversion, they put a catastrophic nurse case manager on a non-catastrophic claim, and they billed $1,130 for that. Now that doesn't seem like, hey, I've got millions of dollars running through my program. It all adds up. If they've done it on this one, then where are the rest of them? Duplicate bill charges. See, this is where, we probably see this more often than not when we take business on. 200 duplicated bills. So it's $9 of bills. It's not a big deal, right? $1,800. But again, it's the idea. What else, is being done by, the TPA that could be expensive as well? Because all of these things add up in the loss fund. And I don't think anybody wants to answer. Oops. Thought I had one more in there. I think I did, but now I don't. So I cut it off. I guess it's a version 2 or something like that. It's the transparency piece of it. And ALAE, it can erode your overall loss fund very quickly if you're not paying attention to it. And we can do that. I mean, as a TPA, you're hiring us as a fiduciary. That's what we should be also looking internally at that. But we should all be transparent of, if I put a nurse case manager on this claim, here's why I did it. And if you don't agree that I did it the right way, then we'll most likely we'll discount the bill, right? We'll discount the time. Many times, because we don't actually have the gold, so our clients really have the golden rule on this one. So a lot of times, we will we'll look at it and say, you're right, we shouldn't have done that. That was done incorrectly by, adjusters drive this stuff. Look at, anytime you have catastrophic losses, really map out what the process is going to be, because there's so much capability of putting a lot of extra cost into a catastrophic claim. And for the most part, you should be working with your excess carriers. You're going to work with defense counsel. You're going to work with, your whole team on that. So make sure that you work with your whole team on a catastrophic claim. And make sure that ALAE just doesn't creep up and smack you, because I don't think anybody that's heading up risk management here wants to go in and tell, whomever their boss is, that, oh, by the way, I've got about $20,000 extra that I wasn't planning on that has come through these other services, that those services don't appear to have had an impact on the claim outcome. And I think that's the real, question you ask. Did those expenses and those services have an impact on the overall claim outcome? And if you can answer that question, yes, then it's easy. But if you say, wait a second, why did that happen? I happen to be gone to, Portugal and Spain and elsewhere, and all of a sudden a couple of things came through. And, it just happens, and it's an unfortunate part of our business. And just so you know, I've never handled a claim in my life. So other than being on the approval hierarchy, I've never sat in a desk and just handled and adjusted a claim. I come from the underwriting side, where I always look for, abuse of the ALAE. People would send in their loss runs, and it's like, well, wait a second. The average for a state is, 12% of total loss. How come you're at 18%? Or how are you doing it at 6%? Because that's also important to understand how they're performing better than maybe the state averages. In California, I think the average ALAE is about 40 to 45% of a claim, a lost time claim. Incredible, right? I mean, it's 1.5 times your cost. So preventing claims is great, fabulous. Getting people, back caring for them, getting them back to work as quickly as possible, fantastic. And when you do that, you will control your allocated loss adjustment expenses to a point where you're going to say, wow, why didn't I do this earlier? And I say it's simple. This is not a simple business. We have a lot of turnover in our business right now, and it's just because we have an aging population. I think the average adjuster is 51 years old or something for a senior examiner. So that's an older market from the standpoint of age. And, you know, you just saw the numbers that they get paid. You know, they're demanding more and more and more. I don't know what Pinnacle, you know, insurance carrier side of it, but on the TPA side of it, you know, it's you know, every day is a new challenge, which is kind of fun, right? No easy day, but yesterday, right? Right? It's thing. So with that, just any questions? I know I ran through it pretty quickly, but I did cut off that last bullet point for you, so we can take some questions. I just want to know, because I also came here for the free lunch, and then they told me I had to do a presentation. Any questions? Nothing? Anybody have any stories about runaway ALAE? No? All right. Well, thank you very much. I appreciate it. I think I got it back in time almost.
Yeah, great, good. Very awesome. Ray, you're presenting next month, just to let you know. All right, well, that concludes our program today. Couple of things. Remember, our holiday luncheon is now on December 14th. Also, if you're interested in running for one of the open board positions, please let any of the current board members know. And we will see everyone in a couple of months. Thanks for coming.